Hello everybody, this is Christina and Laura here. We are the National Standards team and welcome to our webinar. We're just going to be talking today about what the standards are, what is the field talking about, and we're going to hopefully answer a lot of the questions that you have about the standards process. And one of the big questions that we hope to answer is, why do you have to even go through this process, or why should you go through this process? So thank you for joining us. As you can see here, this is Laura and myself, Christina. And yes, I know that it looks like we are twins in this picture as far as our clothing. That was not planned, but I think it is appropriate. So that's our contact information, and we'll have that available for you again later on if you need.
I always like to give a little bit of information about why on earth you would listen to either of us about the standards process. So just so you know, I came from a community foundation and I am a product of a community foundation, all from Indiana. Thank you, Indiana Philanthropy Alliance. Thank you, Lilly Endowment, for the opportunities to be a scholarship award winner, to be an intern who got paid, which is so unusual, and then to have a vice president position at the community foundation in Lake County called Legacy Foundation. So that's, you know, I've had my whole career in nonprofits, in enterprise zones, and in different types of foundations, but my love and passion is really about community foundations, and that's why I'm here with Christina presenting. Christina will tell you now a little bit about her social justice background.
Yeah, so I did come from a little bit different background. I came from a litigation background. I fairly recently relocated to Washington, D.C. from Los Angeles, where I was practicing in the area of housing rights, specifically eviction defense. So my background, as Laura mentioned, is in the social justice arena, but I do find that there's lots of correlations between that and the work that I'm now doing here at the council with community foundations and all the great work that community foundations are doing across the country.
Basically, Christina and I live to make sure the community foundations do work well. And I guess live is an overstatement. I think Christina should get vacations and you know, some weekends, but we are very excited to be here and to support you.
So we're just going to sort of go through this agenda here just really briefly. And the first part that we're going to talk about is, why do we even have this program? Why do we want to self-regulate? The second part that we're going to go through is, what are the actual national standards? What do they look like? What does it entail? And part 3 and 4 and 5, so we're going to go through some of the common community foundation legal issues and frequently asked questions that we get all the time. And this should hopefully answer a lot of the questions that you have. And then part 4 is the actual process of applying for accreditation with the National Standards Program. So we're going to go through that, and then the last part is going to be really more tips specifically tailored to help you through the application process. And so yeah, so we're going to go ahead and start.
Okay, so part 1 is, why are you adding work for me and my foundation? A common question that Christina and I receive about the standards process. Well, I would like to take, you know, the first half hour with Christina, or 20 minutes, and talk about, why does anyone care besides Christina and I about this program? First, before we get into it, you should know that national standards were not created by staff at the Council on Foundations. They were created by you. The field chose to give itself homework and to do extra work. I love that about all of you, because you wanted to show state, federal, local regulators and donors that community foundation means something, right? It is an entity, and when you go from community to community, if you find this organization you will find a partner that thinks about community leadership, that knows the charity space in your community, and wants to work with you to preserve the great things that are going on in your communities and to make your communities even better. So first, your evidence for excellence, right? The dollars set aside for the work you're doing are limited, and you're there getting some of those dollars. Second, you're accountable. So I know all of you like to say, if you've met one community foundation, you've met one. But regulators would say, that sounds like the Wild West of charities. What are you talking about? So while you are all very tailored to your communities, you do have general operating practices, and that you demonstrate them through the National Standards Program. So this is a way of saying, well, we're customized to our community. We all recognize that there are practices for our field of work, and we do those practices. Next is impact, right? So community foundations help not only have impact in their communities as a single entity, they work in partnership. They provide a framework for documenting the work that you do with your community, and that you can display that work to not only be important to the community needs, but done in the best possible ways to follow rules that apply to your foundation. So Christina is now going to talk about why we would ever try to make you do more than what the law requires. And don't forget, when I say we, I'm not making Christina and I the bad guy. I'm talking about the field.
Thank you, Laura. So this portion is really a lot of the meat and potatoes, if you will, of what national standards is and sort of where it comes from. So this portion, we're really going to talk about understanding what keeps regulators and policymakers up at night.
And it's you. No, I'm just kidding. It's not you. It's not you. Okay.
So I recently, on October 17th, attended the annual NAG-NASCO meeting here in Washington, D.C. And for those of you that may not know, that is an acronym for National Association of Attorneys General and National Association of State Charities Regulators, or officials rather. So, so these really are where a lot of this information is coming from. It's coming directly from them. So Laura and I are not just, sort of arbitrarily telling you that you have to do these things or that these are issues. These issues are actually coming directly from attorneys general and from state charities officials as well.
And historically, you all have picked up on that, and that's why when we bring teams of community foundations together to revise the standards, you all are basing information off of what you're hearing at your local levels, which often mirrors what Christina and I hear at the federal level.
And this also just shows, Laura and I are not just sitting in the office all the time, although we do that, a fair amount of time, but we are also out there. We're in the field and not only, meeting with community foundations, but also meeting with, like I mentioned earlier, state charities officials and attorneys general, and not to mention, Laura meeting with Treasury. So we kind of both wear several different hats. So this is just one of the hats that's part of the National Standards Program that both Laura and I wear. So at this NAG-NASCO meeting on the 17th, they had one panel that was specifically all geared towards board education and the importance of board education. And so out of that came the top 10 state charities issues and really how to get investigated by a state regulator. In other words, what not to do. So I'm going to go through these now. So the first what not to do is to have an absentee board and or a lack of board governance. So the panelists were talking about directors and senior leadership failing to be sufficiently active and informed. So, this really comes in, in different formats and different forms, if you will. But essentially, they talked about the importance of just a basic education and even just a basic orientation for board members on the front end. And also that helps with, they talked about the thinking strategically and really building a good pipeline for your board members down the line, including recruitment. And you know, it's just a way to have a healthy board. And having a healthy board means an informed and active board. So that was the first big issue that was discussed.
So I know some of you on this recording, who are listening to this recording, are saying to yourself, why? Why standards? Why do you require so much board information? I have a governing board, not an operating board. They're high level. I can't get them in the weeds this much. It's because when you are investigated by a charities official at any level, they never say, what did the CEO know or what did the staff know? They ask, what did the board know? And last year at the State Charities Conference, they said one time that they investigated a board didn't even know they were a board member. So we know that's an extreme example. We know that's not happening with you. But this is the #1 issue for state charities officials. #1. It is not us who are the bad guys in the standards. We are the messenger asking you to make sure your board is informed and to demonstrate that to us. And I know how much you all dislike it, but we're doing it because we love you.
Yes, and just to echo that sentiment from Laura, the panelists at the meeting specifically under this topic discussed the idea of setting proper expectations for board members, especially prospective board members. So I know that, you know, everybody is really busy and has a lot of things going on, and many of your board members may be, you know, top-level executives in their own right at their particular community foundation. And so sometimes I think we may have the tendency to say, you know what, just join our board. It's not that much of a commitment. You know, just no big deal. You won't have to do that much. But that's not really the case if you really want to have, you know, an effective board and, you know, not have an absentee board. So just think about that, and again, that kind of goes to the issue of the pipeline. You want to have, of course, you know, fantastic and qualified people to be on your board, but also persons who are going to have the, you know, the ability to commit the time that's really needed to be part of an effective board. So the second issue that was discussed, what not to do, is not safeguarding assets. So being on the board, you have a duty of care to your organization. So issues like fraud and embezzlement are, of course, of top concern. And also, you know, is the issue of failing to adequately protect donor information. There was also a separate panel at the NAG-NASCO meeting specifically talking about cybersecurity and issues surrounding that. And so I think these tie in very well with each other to just really drive home the importance, again, of safeguarding all the assets, and especially, of course, donor information, and just having those policies and procedures at the ready and have them in practice. One of the panelists was talking about the fact that you need to have things in place before. You can't just do it sort of on the whim once something bad does happen. So, you know, when information accidentally gets dispersed, that's, you know, confidential information.
And this is why standards is so great, because we help you not wait until there's a problem. A couple of things here. When thinking about not safeguarding assets, when it comes to embezzlement, and state charities officials, of course, care about that, we want you to know that we don't think any one of you is a bad actor. But what we do know with embezzlement cases is that people who do this know how to target nonprofits. They do their research. They look for holes in your due diligence or in your staffing, and they infiltrate. So we're letting you know that nonprofits have a marker on them from time to time, and we're hoping standards helps fend off that marker on your community foundations. Additionally, you've heard us talk about privacy policies and standards, and we tried to have you all submit, we've tried to have you all agree that you have one. People seem very confused about privacy policies. Privacy policies are different from confidentiality. Privacy policies are about the data on your website, and even if it's provided by third-party providers like PayPal or Authorize.net, or you have a scholarship program that you're using through FIMS or Pearl or Fondant, whoever, you still have to know their privacy policy as it applies to people using their sites under the auspices of working with you. So having a privacy policy right on your website, making sure people understand that when they're sharing information with you, how they're sharing it, you have to be thinking about this, even though I understand in your day-to-day work it's not coming up. Lucy Bernholtz at Stanford Social Innovation Review has a lot of information about privacy policies. It's certainly of high concern for her. She was actually, I told her that Standards was including asking about privacy policies, and she was happy to hear that. We could go on and on about this, but the point Christina and I are making is privacy policies are no longer an option. You all have to understand the risks to people visiting your sites and using your sites when you decide to adopt technologies, from your website to your donor platform to your scholarships and grant platforms and everything in between.
Thank you, Laura. So the next issue that was discussed at the NAG-NASCO meeting was the issue of conflicts of interest. So, organizations, of course, have to address actual conflicts. And quite a bit of this portion of the panel actually spoke about the increased need for, organizations to defend themselves against the appearance of conflicts or impropriety. So you might run up against an issue where something might not actually rise to the level of a conflict. However, the appearance could be that perhaps there is a conflict or some type of impropriety. And so this is something that was really stressed in this panel, in this specific portion of the panel. And I think that's something that's really interesting and really important for community foundations to be aware of. The sort of tagline that they used was, would the media and your mom understand?
Right. And this is another great point that Christina brings up about there is a difference between what is required in the law and what are the risks that you are legally taking on. And we get a lot of calls at Standards and at the Council on Foundations legal desk about, oh, I have a feeling in my stomach, I don't know about this, it feels like a conflict. What is legal is different than what is possible. And what is possible should have a weighing of risks for your organization before you jump in. And that's really what Christina's getting at when she talks about the media and your mother. Because the court of public opinion is much more active with charities sometimes than the court of law. So just remember that court of public opinion. Christina's put it up here for you beautifully.
Yeah, thanks so much, Laura. Just to add a little bit to that, so it's really, I think, important to ensure the resources that you have as a community foundation. So those resources are things like people, money, of course, and your reputation. Like Laura said, the court of public opinion can be pretty harsh at times. So that's something that you definitely need to think about. And really, another issue that was stressed is just thinking beyond the conflicts of interest policy. So understanding up front what a conflict of interest is and what constitutes a conflict. And going along with that, making sure that your board members are disclosing conflicts in transactions that should be on the 990. And also, as part of Standards, we do have the conflicts of interest policy that we require for you to submit as part of your application. And again, this just goes back to the fact that, Laura and I aren't just arbitrarily asking for this information. It really is information that the, state charities officials are wondering about and bringing up as concerns. So just to tie that in a little bit more. So the next issue is excessive compensation and/or executive director that has too much power. So you need to think about what are like organizations paying for like services. And also, just because a particular number might be thrown out there as far as compensation, and even though it may be a comparable amount of compensation, it doesn't necessarily mean that you have to go with that number. So there's, again, you can kind of think outside the box a little bit and just kind of keep these things in mind. Another sort of sub-issue, if you will, of this particular portion is in regards to the CEO having too much power, too much control. This may be a president/CEO, it may be an executive director of your community foundation, but remember that the executive director and/or president/CEO actually reports to the board as opposed to the other way around. And sometimes that can be sort of flip-flopped, if you will. And that is of concern for charities regulators or charities officials. And also in that same vein, they did talk about some of the ways that this type of issue can come up most regularly. And one of those, or two of those actually, would be a situation where the CEO is essentially handpicking the board, selectively choosing from friends or other people that they know, and really just picking those specific people, and probably for specific reasons as well. In that same vein, controlling all the streams of reporting to the board is a no-no, and you want to look out for that. Your foundation staff and other employees besides the CEO and or president really should have a direct way to communicate with the board if they need to. So that's just another thing to look out for and just keep in mind.
Yeah, a couple of additions to that. One, if your board doesn't go to an executive session without the CEO, do that once a year at least. And I know all of you are laughing about the idea of excessive compensation. I hear you. I know what community foundation leaders get paid. But we still need to be aware of that. We need to be aware of what people get paid in like organizations. And of course, standards asks you to show that the board evaluated the executive director's work, including evaluated the salary for reasonableness. So we do help you have some standards for this, but Christina's provided you with great ideas.
So the next issue that I wanted to bring up was the idea of a clear failure to follow the mission of the nonprofit. So the idea of the board being asleep at the wheel was brought up, and the importance of this not happening, of course, is what was stressed. So it really is imperative that the board upholds the duty of obedience and to avoid what could be called mission drift. So, and this is something that I've actually, seen and heard a little bit in my, time here at the council happening with community foundations. And so it's really important to keep aware of your actual mission and to make sure that you're not being steered away from that mission.
Now, with all of you having community leadership in the definition of a community foundation at this point, we understand that that can mean a lot of things in different communities. In some communities, it means getting into diversity, inequality head on, right? And we applaud that. In some, it means offering space, right? Buying a building that has pros and cons. And don't forget that as you take on community leadership issues, community leadership and leadership generally is hard. People who lead aren't always popular. And so making sure the board and staff are clear about where they're going and why, and hopefully documenting it on paper somewhere, memo to file, I love a memo to file, really helps show that you've taken deliberate steps along the way and that you're not just following the whims of an individual donor or an individual staff member or an individual board member.
Exactly. So next issue is in regards to membership issues and managing board conflicts. So I thought this was really poignant. So the panelists said, if you don't resolve your conflicts internally, then we will. In other words, the regulators will. And that is definitely something that you do not want to deal with. So yeah, just being aware of the importance of having policies and procedures in place, like for instance, whistleblower policies, and then actually following them, this was stressed. So I think it's one thing to have the policies and procedures in place, but you have to actually follow them and comply with those to really, have an effective, vibrant community foundation.
Such an important point, Christina. I love this bullet point. We could have planted it, but we didn't. So, a couple of things here. One, remember that conflicts are not just with individual board members and outside entities or staff. It is also among board members. So if you have 7 board members and 4 of them are engaged in a business transaction together, they might be seen by regulators as a voting bloc, because if they make each other mad, they could jeopardize an outside of the boardroom business relationship. Those conflicts need to be put forth. They need to be put forth in the same way at every meeting, right? So if you have, are people staying in the room for discussion? Are they leaving? Are they in the room for the vote, or are they gone? Whatever your policy is, you should follow it every time. And we know that you all dislike that we've asked in your minutes to report conflicts, and we all know that we get the whistleblower policy back a lot, and you say, why is this thing so broad? But this is why. This is what your regulators, your state and federal regulators are looking at, and we are trying to help you be proactive so that you don't get caught in a bind later.
So the next issue was just really discussing misuse of endowment or restricted assets, and really a de facto application of this legal theory called cypre. So basically, it's important to remember that you have a duty to prudently invest and a duty to supervise all investments and advisors. So you need to follow the restrictions on donations and keep good records, such as fund agreements. And that is another big part of national standards, is that we do require you to provide your sample fund agreements. And again, this is part of good record keeping. It's not just Laura and I wanting to look at all of your fund agreements. It really is critical to have this type of documentation. So, and this type of legal action, really, it can be long and extensive. And so, it's something to, again, to keep in mind, to keep at the forefront of your operations, and especially when you are either applying for accreditation for the first time and or whenever you are applying for renewal. These good record keeping is going to help you in the long run.
Now, we know some of you, looking at your endowments and your fund activity, do need to look at variance power sometimes, and do need to look at whether a fund has become inactive. And we recognize that depending on your state, and whichever Attorney General you have at the time, the level of reporting and whether or not these are going to be approved are real questions for all of you. And we understand that. And we, at the Council on Foundations, are working with the president of the National Association of State Charities officials to get some clarity here, not just for the field, but maybe some clarity that goes to all the AGs as well. We are not promising any successes yet, but we are promising that we are having dialogue about this, and we know it's a concern.
And just as to drive home the importance of this, there was even a separate panel which discussed explicitly staff, endowments, and other restricted funds and assets. So it really is an area that is getting a lot of attention, so you need to keep that on the radar. The next issue that we're going to discuss is fundraising issues. So professional fundraisers do have to be registered as appropriate, and as you can see, each state does have certain rules on this. Some consistencies are found at the national level, but you really need to know what the particular rules are in your particular state, because they might not necessarily be the same as a neighboring state. And this is something that that is touched upon in national standards as well. So I think Laura may have some additional comments in this regard.
Yep, so just so all of you know, when it comes to fundraising issues, one, the IRS is going to require you to show fundraising on your 990, or you could be flagged for an audit. So we understand there's a difference between fundraising costs, professional fundraisers, and donor-initiated fundraising, right? We know there's all kinds of stuff swimming around in the fundraising issue. Professional fundraisers are very specific, and you need to look at your state laws to make sure you understand this and about who they are and what this means. If you have questions about whether you're using a professional fundraiser or not, you can certainly call us. But if you're paying someone to ask people in your community for money, or to get them excited and prep for an ask, or to talk to them about planned giving, you want to be checking your state law on what this means.
And just a very quick add-on to that, the panelists in this regard specifically brought it back around to board governance, and they specifically, wanted to make sure that the board gets periodic updates on this. So again, it all kind of goes back to board education, board governance.
Right. And I know many of you question the Charleston principles on how many states do you have to be registered in. Is it all 50 because you have a website? Is it just the states where you contact, more than a few donors? So I worked at an Indiana foundation. We had active donors in Michigan, Wisconsin, Illinois, and Indiana. And then we had, a handful of people in other states like Florida who had moved out of that 4-state region. So when you look at that, we definitely want to be registered in those 4 states where we were doing the most work, and then we had to kind of figure out the Charleston principles the best that we could for the rest.
Awesome. Thank you, Laura. So the next issue is the lack of public accountability and transparency. So failure to comply with federal and state reporting requirements and failure to keep adequate and timely records are 2 big things that were brought up and mentioned to be of concern. So, of course, again, these are things that you should not be doing. You do need to keep, adequate and timely records, and of course make sure that you're complying with federal and state reporting requirements. One thing that struck me as far as an example that was brought up was the saving of PDFs of electronic bank records. So one of the panelists talked about a particular organization that was being investigated, and this particular organization had electronic banking records. But the problem with that and where they failed, unfortunately, is that they would get an electronic statement each month or however, regularly the bank would provide the statements, and then they would just delete it. They would just sort of check it, to make sure everything looked okay, but then they never actually saved a copy of those records. And so, most banking institutions will only go back, a certain number of years before you have to go through a whole process to request those records and, go to the actual bank. And, they're not necessarily always easily accessible after that time period. And so this created a big problem for this particular organization. So, just something simple as making sure that you save a copy when you get your statement, it's going to go a long way and it's going to help you. So just things to keep in mind.
Basically what the regulators are saying here is relying on others for your electronic records, bank or otherwise, is about as compelling an argument to them when they ask you for something as the dog ate my homework. So don't have the dog eat your homework.
Exactly. And I'm glad you brought that up, Laura, because if I remember correctly, I think that analogy was actually brought up.
Oh my gosh. I am so in tune with the regulators that we are using the same joke.
Yep. Laura wasn't even there, but she knows.
That's right.
And so we're going to go on to the next one here. And this is a pretty easy, what I would call a no-brainer. So number 10 of what not to do is ignore the Attorney General's office. Don't do it. I think that's all that really needs to be said in regards to this particular issue. But, I guess you'd be surprised that some organizations apparently do ignore the AG's office, but you definitely don't want to be one of those organizations that does that.
They also said this to us in 2015, which means it wasn't fixed in 2016, and we're not blaming any of you, but make sure your grantees also know if something comes in the mail from the AG, pay attention.
Right. And just this is more of a general note, but during the lunch portion of the meeting, we had a sort of almost a roundtable discussion at each of the little lunch tables, and something was brought up at my table that I thought was interesting and of note. So if, hopefully you will never be in a situation where you feel like something has gone wrong and you're not sure if you're, non-compliant with a particular law or regulation. But I actually asked one particular person who was an assistant attorney general. If I remember correctly, I believe they were from Delaware, but I don't recall exactly. Nonetheless, the point that I'm trying to make is I asked them if, for instance, a community foundation found themselves in some type of trouble, or if they think they're in some type of trouble, should they just sort of fall on their sword, for lack of a better phrase, and ask for help from the AG's office, or do you think it would be better for them to kind of, try and go it on their own? And across the board, the actual couple assistant AGs that were sitting at my table, they all said, come to us. We're here to help you. We don't want to punish you. We really do want to help you. So again, this is just sort of a broad and general note, and hopefully none of you will ever find yourself in a situation like that. But that was just something that I found to be of note that may be helpful to anybody who unfortunately may be in a situation like that.
Thank you so much, Christina. That is so helpful. And I appreciate that you give another note that the board has to be involved. Again, this is not Christina and I saying this to you. This is your state charities official.
Mm-hmm. Yeah, and so definitely, I mean, the takeaway here is that adequately educating your board is key. It's paramount. And, a lot of problems can be prevented when you do have a board that is educated and knowledgeable and engaged on top of that. So thank you.
Great. So now I'm going to go in and talk a little bit about the federal charities issues that we know about. And we take these from the IRS's famed Dirty Dozen list. But then we also, as Christina said, we don't just attend state-level charities official meetings. We also try to attend federal-level meetings called TEG meetings. And that's where we hear from the IRS and the Treasury about what they're working on, what issues they're seeing, and that's really helpful because then when we go in one-on-one to talk to them, we've kind of got ideas on what they're working on. So the big thing with the IRS Dirty Dozen list is fake charities, which we already talked about in Christina's section, but just know everyone's always looking for fake charities or illegitimate use of the 501c3 rules by bad actors. And again, we're not saying any of you are bad actors, but bad actors know how to find weak systems and exploit them, so we never want you to be that. The second thing they're looking at is the public support test has changed, you know, in the last decade or so, and the unusual grants rules and the tipping rules and how to calculate the public support test, the revenue procedures for that did not get updated at the same time that the public support test was updated. So we're going to be seeing regulators kind of fix for the discrepancies and lag time in laws versus procedures. This is important because community foundations are publicly supported and have to pass the public support test, but so do your grantees. So we at Standards and of course the Council is keeping a close eye on this, meeting with Treasury and trying to figure out what is it that they're looking at here and what issues are they trying to solve for, if any, besides just updates. The next thing is determinations and when you can rely on a 501c3 status. So we all used to have publication 78. Oh goodness, I have a typo, 788. No, that's not it. 78. My apologies. And now we have EO Select Check rather than publication 78, which is sort of an online system. But that EO Select Check may not be the most updated, or it may have a time lag in what's been provided. So they're going to talk to us about when we can rely on that, which should also be helpful, hopefully, for some of you who have questions about whether you can rely on the 1023 EZ. Okay, next they're looking at supporting organizations. So all of us are warm and cozy with the Pension Protection Act of 2006 at this point. We've all lived through the pain of a lot of changes. And the federal government is here to tell us we may not be quite done. So there's a lot of things that passed in law that now regulators have to write into the law. So passing a law is very different from writing how you have to follow the law. And so we've got a time lag for the Pension Protection Act, and one of those time lags is on supporting orgs, and they hope that they're going to have the last bits of that information coming out, quote unquote, soon. And I will never say, nor will probably your regulators say what soon means. But soon means it's in process and it's pretty far through the process, as opposed to being drafted for the first time. And we've seen draft regulations here, and we've commented on those regulations, and I'm sure many of you have too. So if you have supporting orgs, please be aware of that. So the other issues that we see that they're looking at are excise taxes related to donor advised funds. How many times have we talked about pledges and bifurcation and how donor advised funds can be used? Who can be the advisors? Can it be a group of unrelated people? Should it just be families? There's a lot of questions about proper use of donor advised funds. So Treasury is actively working on this right now, and they are looking at permissible versus impermissible uses of putting money into and distributing from donor advised funds. As you can imagine, The council is watching this as closely as humanly possible, meeting with the Treasury. I would say, gosh, at this point, we have run-ins at least every 6 weeks. I'm in a lot of those meetings. We've sent in memos regarding information about how community foundations use donor advised funds and all the great ways that you use them. So please know, every time donor advised funds come up, we know everyone starts getting very concerned. We're on it, we're following it, we're asking them to be surgical in their fixes and precise if they need fixes because these funds have been used illegitimately. I will tell you, at the regulatory level, we don't see a lot of discussion about the different types of sponsoring orgs, community foundations or others. That's just not part of the discussion. We've brought it up. That just doesn't, that's not part of what they are deliberating about right now, and the council's talked to them in the past about that. Again, they didn't have an appetite for deliberating at that point. Next thing, reporting contributions in Schedule B. All of you are familiar with Schedule B. You all know how sensitive the information is on it. It's usually redacted for any purpose except the IRS, and it looks like we'll be getting additional information on whether there needs to be changes. And we think that's because as the government goes online more, there's more opportunities for hacking, and so how to protect Schedule B information may be what they're alluding to, but we don't know just yet. The next thing is how partnerships are audited and checked for transactions with disqualified persons. Now, I know disqualified persons is a private foundation rule, but many of you do deal with conflicts issues. More and more foundations are getting involved in public philanthropic or public-private partnerships, and there is a recognition by the Treasury that exempt organizations are affected by this issue, so we're going to see more information. I don't have a lot more at this time, but we can see sort of a theme here, right? Are people behaving appropriately within the 170 contribution rules? Is anyone getting excess benefit or finding avenues to impermissible benefit or private inurement? That's what they're getting at. You can see that's kind of a theme throughout some of these. Okay, next is 170 charitable contributions. Not sure if many of you have water rights or restrictions to prevent easement perpetuity or qualified appraisals and appraisers, but if these issues are things that you're dealing with, water rights, easements, or qualified appraisals and appraisers, just keep watching the Council on Foundations Washington snapshot and keep looking at stuff from the council, because we will be watching as things about this trickle out. But this is what we're hearing from our charities officials at the federal level about what they are thinking about. And I will tell you, we got some of this information off of a call from this morning. So I'm hoping that I'm reporting to you accurately. I want to disclaim that I am not a representative of the Treasury, IRS, or state charities officials. And if I've gotten anything wrong here, that's on me and not them. But we do the best we can when we're reporting back to you. Alrighty. So self-regulation is catching on, and I wish that I could tell you and I could take credit for planting a board member in my success story, but I cannot. Jim Williamson brought this to us. He is a board member of the National Standards Program, and what happened to him is that they did a petition in their probate court, and when the court was reviewing whether or not the community foundation should take control of some assets, the Attorney General's office expressed that national standards accreditation represented high standards of accountability, and the court ended up ruling in favor of the community foundation, and I don't know if I can say in part due to the testimony of the AG about our great program. I won't say what, how the court linked these, but I am saying it was in there, it was an important statement, and this case did come out favorably for this community foundation. So know that we don't just take the information that we get from state charities officials and bring it to you. We also bring it back to them so that they have an awareness of how well you all are operating and looking into yourselves and checking, what is it called, crossing your T's and dotting your I's, all the good things. This is an example that there is awareness. It is a thing that people know about. Okay, so now I'm going to hand it over to Christina. I'm going to take some deep breaths, drink some water, and let her tell you about the standards program.
Thank you, Laura. So this part is really geared toward the actual standards. What are the national standards? So as you may know, the national standards for U.S. community foundations is an accreditation program. And so the program promotes operational effectiveness to foster excellence in community philanthropy. And we do this in a couple of different ways. So first, we have created the standards. And the purpose of the standards is to really have operationally and legally sound community foundations. And two, we lead community foundation staff and boards through the process of achieving operational excellence. And so really, one of the goals is to really give you as community foundations confidence in your operations, to know, that you can help solve complex social problems, but of course, still being operationally sound.
Right. So we just went through all of the risks for you, all of the reasons you shouldn't do anything and you should almost feel paralyzed to exist. Just kidding. Shouldn't feel paralyzed. But we've just gone into all these sort of like scary situations, and we know you're all probably feeling like, oh gosh, I'm not going to do any of the new ideas I've heard recently after hearing that AG and federal regulators information. But the great thing about standards is it is the cornerstone of your operations, right? Once you know you have passed standards, you know your organization has the tools and policies and procedures to run according to the law. And so you can take risks. You can look at new projects or take on new partnerships and ideas, because you won't kill your whole foundation by trying to take risks, right? You've got a really, really sound entity that can go ahead and do what it needs to do for the community. So when we think about who participates in standards, I'm going to do this part because I'm so used to saying it so quickly. And one of the things that Christina and I want to present for you all, and maybe do a happy dance with you, we've been talking now for a while, you probably need to get up anyway, is that we used to say that 49 of the 50 states had at least one accredited community foundation. And as of today, we can say that 50 out of 50 states have accredited community foundations. Thank you, Montana. So Montana had nothing against the standards. They've been working on it, and now we can say we've got all 50 states. So first and foremost, who participates? All 50 states, right? Second, how many, about what number? We usually are around the 510 mark for the number of community foundations accredited, and that's, depending on the day, about 780 total community foundations in the country. So a majority, a high majority. The next thing that people ask a lot of times is, well, who participates? Is it the big ones? Is it the little ones? What we know is that we cover the breadth of community foundations. And I really have to point out that the leaders in the community foundation field who came up with the standards program really thought hard and were successful in creating a program that fits all types of community foundations under its umbrella. Now, that doesn't mean to say it's not painful for some of you. The small ones, it's a lot of paperwork for a small staff. The big ones, we're asking you to cross I's and, cross T's and dot I's, and you're probably saying, why can't you just know that we're a solid operation that has the infrastructure to do this? We hear all of you. We respectfully disagree. You still all have to do the same things. But you're all still in it and participating. We have almost all of the largest 25 community foundations. We just have 1 or 2 who don't participate. And a third of all of our community foundations have $10 million or less. So that really speaks to the design of the program. And again, back to the field who helped create it, you all were so forward-thinking, great work. Now the next thing what we all want to talk to you about is the national standards. When I came on over 3 years ago now, gosh, I'm getting old, the program had a seal, but it did not say accredited. It's on the left-hand side. And many of you were saying, can't you tell the world that we're accredited? Like, can you give us a seal that says accredited? So the standards program has redesigned the seal, and it does now say that you're accredited, and the marketing materials are in the toolkit where you've always found them. But we are asking that you all start moving from the old logo to the new logo. So when you print your next business cards or your letterhead, or when you do a website update, please, please start using the new seal. We will be most appreciative. It hurts Christina and I every time we see an email with the old logo on the bottom. So please update your seal. All right. Now, this is probably what you've all been waiting for, the section where we actually talk about how to pass these darn standards. So I won't delay. I will just dive in and talk to you about some of the most difficult issues, or the most common issues that we see over and over again in the application. So the first one we're going to talk about is the non-discrimination policy. We want to see this policy applied somewhat more broadly than people are used to. So we need to see it for staff, we need to see it for board, and we need to see it for grantees. Now the csstandards.org website has a sample that covers all of this. That we have 2 different ones. It's sort of the internal and then the grant making. Please, please review these. If you have problems because you believe you're making discriminatory grants based on the funds you hold, we get that. We understand that some of you hold religious funds and other things. But let's talk through that, because that is what we want to see at this point. And our samples use language that we got from U.S. government websites, but we understand that there may be different languages if you want to use, as long as you cover the legally protected classes in your non-discrimination, then that will pass standards. The next is, what you all know and love, which is the donor advised fund policy. So the donor advised fund policy has seen changes over the years, especially since the Pension Protection Act of 2006. And that's because once the law came out, we weren't getting all the regulations that we needed. So we had some information. We didn't have all of it. And the council has been doing its best to make sure we're not only keeping up with what the law and the regulations say, but that we also are including information that we know may be coming or we know regulators may want to see. So the biggest thing we know about your donor advised fund policy right now is, 1, you shouldn't be too deferential to your donor. Remind them that you have variance power. Remind them that you have exclusive legal control. Don't hide that information from them and say, oh, well, if you connect the dots through 4 different policies, you might figure out that we have exclusive legal control and variance power. No, no. Make that language plain and straightforward. The second thing is, we want to see fund making, donor advised fund activity policies. So many of you have called this inactive funds for a long time, an inactive funds policy. The issue with that is when you go to your donor and you have to use it, you're talking to them about something that sounds bad instead of something that sounds good. The same thing when you talk to a policymaker. If you come in talking about how you have an inactive funds policy, you kind of hand them part of the argument that you do in fact have inactive funds, or you wouldn't have to have a policy about them. So what we want you to talk about is grant-making activity, right? How are your funds active? How do you work with your donors? Is your donor saving up for retirement so that they can stay connected to the community by giving in retirement? Are your donors trying to build up a fund so they can make a big gift? Are they looking at a capital campaign? There's many different issues that we can highlight for how you've worked with the donors and know that how they plan to be active with that fund. In addition, many of you have been putting out information in your fund statements about, oh gosh, my brain. Sorry, many of you have been putting in your fund statements information about projects that you're doing and inviting your donor advised funds to participate, inviting them to participate in site visits or collaborative projects. Please continue to do those type of things that are actually reaching out to the donor to utilize their donor advised fund instead of waiting for them to tell you how they want to use it. You'll see more information from us on grant activity policies coming in 2017, and we'll have samples and we will help you with this, but please know the trend is make that fund active, be proactive with your donors. We understand that means a lot of different things to a lot of different people, but know that we are trying to define that broadly so that the many ways that you work in your community are expressed in the grant activity policy. Next thing, everyone, and I repeat everyone at this point, please only give us signed Form 990s. We need to know that the 990 you're giving us is the 990 you've actually submitted. And we don't know that unless we have a signed 990 or Form 8879 that you sign when you file an electronic copy. If we do not have one of these two signatures with your Form 990, we have no way of knowing that it's the one that you actually filed. Pardon me. See, I'm so hoarse from this because it's so important to me. I'm really yelling about that. So please only provide signed Form 990s. Christina and I probably have to send back 9 out of 10 applications for this issue.
And just to quickly jump in there, Laura, on that. So the 990 or the 8879 should be signed by the corporate officer and also by whoever prepared the forms.
Right.
And sometimes we see, most of the time we see no signatures, or we may see one or the other signature. So just to add on to that.
And if you don't use a professional service provider, maybe just make a note to us, you know, we do this in-house, just so that we know. Otherwise, we may send it back to say, did your advisor sign it? So just, if you don't work with an advisor, if it's done in-house, tell us. Okay, confidentiality policies. Get a lot of questions about this, whether they have to be signed every year or if they should be signed one time by the people that must sign it. It should be signed one time, but if you feel that you need to reinforce the importance of your confidentiality policy, you can certainly ask them to sign it again. And remember, when you think about who confidentiality applies to, think about who has access to sensitive materials. Is it just your board? Is it your staff and board? Is it your staff, board, and committees? And sometimes you have committee members that aren't board members. Really think about the breadth of people who are receiving information that's confidential and make sure that they are covered in the policy. Next thing, investment and spending policies. We need both, not one or the other. And we need these because one of the core ways you are defined as a community trust / community foundation in law, in federal law, is that you have reasonable returns, investment returns, and that you provide financials to the public, right? So this is really core. This isn't something that can be skipped, and we hear more and more that people are unsure how to read their investment returns and how to evaluate what they're getting from their investment advisors against their investment and spending policies. We will do our best to try to work with you on that, but we do know that that's important. Okay, next, conflicts of interest. You heard us talk about this earlier. It's a huge concern of our state charities officials, and it's a big concern in our for our federal regulators, because this is where you find that private inurement and private benefit. And this is what's really, you know, stressing everyone out right now who's writing laws. So, one, conflicts of interest have to be filled out every year. Two, you want conflicts of interest from board, staff, committees. Three, you should provide an example of a conflict that was brought up at a board meeting and put into the minutes of how you addressed it. And I know some of you are thinking board minutes are for votes, but here's my question to you. If you have an attorney general come and ask you whether or not there's a conflict of interest and you have not recorded information in your minutes about this particular situation, how on earth are you going to prove that you dealt with a conflict? So I know I can hear you stressed out, sighing at me, and I get it. But again, Christine and I do this out of love. Okay, so with conflicts of interest, the most important thing to remember is do it once a year, know the process, do the process every year, record the process. So hopefully that's a good reminder for everyone that when somebody pushes back, this isn't just something you made up. This is how conflicts of interest have to be monitored and disclosed. Okay, next thing, whistleblower policy. Whistleblower policy is one of those things you saw the state charities officials care about. And they want to know that you are talking to, or that you're allowing this to apply to both internal and external parties. And internal parties means board, staff, committee, and volunteers, and external parties means agents, consultants, and vendors. And some of you have said to me, how the heck is a vendor even going to know that they have access to this whistleblower policy? So this is one of those cases where it's not a problem until it's a problem. If they want the ability to whistleblow, they need to know that they have that ability. And when the time comes, they would know if it's in your policy this way. So please make sure internal and external parties, look at the names of the types of people in there. We always are sending these back because you've got board, but you don't have staff, or you have board and staff, but you don't have the external parties of agents and consultants or vendors. So please, please, these aren't either ors, it's an all, and make sure you've got those in there. Next thing, variance power. Cannot stress enough that we expect to see variance power in all of your restricted fund agreements. And we'll go into what's a restricted and unrestricted fund on the next slide. But all restricted funds have to show variance power that gives either the federal language or your state UPMIFA language on, you know, it's going to be words like impracticable, impossible, issues that frustrate the purpose, that allow you to vary the donor intent. And again, you heard Christina talk about how donor intent and endowment are things that state charities officials are really checking on. So you really, really want to be clear with your variance power. While you can put it in your bylaws and say see bylaws, again, I'm not a fan of hiding it, and I know that you're all probably arguing against me calling it hiding it, but the more that we're upfront about this, the better off we are. If you're a fundraising officer on the phone and you're shaking your head at me, I know, I fundraised too, but here's what I'll tell you. The Council on Foundations legal team is right now inundated with calls from CEOs who have transitioned into the position and are now in the everyday situation of having to redefine what variance power is, redefine donor intent, continually check to make sure that Donors understand the restrictions, because if you push too far in your fundraising and you say too much, you leave others in the organization with continual redefining throughout that relationship. And not just the people who sit around you today, but those who inherit the work that you did. Last thing, scholarship committees, and I will even deep dive into this one for you all. Scholarship committees, after the Pension Protection Act, have very specific non-variable rules. One, if the donor is involved, this is only for donor-involved scholarships, the donor cannot be, and the donor and donor's friends or advisors or family members cannot make up a majority of the scholarship committee, right? Your donor has a minority interest in that committee. They are not allowed to single-handedly select who receives the scholarship, and they're not allowed to control others in that decision room, which means if you don't have a staff member in that room for the deliberations, you should be collecting score sheets. You should have some sort of backup that shows how your committee came to that decision with no conflicts. Two, you have to provide the scholarship committee members and the purpose of the scholarship to your board for approval every year. Many of you do this in an Excel spreadsheet. The board is supposed to really check those conflicts. Now, many of you are saying, there she goes again with board approval. Don't forget, for purposes of standards, what we mean when we say board approval is board approved or board delegated with proof of board delegation and an explanation of how information delegated gets reported back up. And again, I know a lot of you are saying, once it's delegated, why does the board need to know? But hopefully we spent an hour making a decent argument that we are not the bad guys. We are telling you what we're hearing from state and federal regulators. Okay. Now, when we get into fund types, the first thing I want to talk about is unrestricted funds. Unrestricted funds do not require variance power and fund agreements the way everything else does. Now, this means donors haven't put restrictions on the gift or trust, and the foundation gets, there's no advisory privilege. This is outright gifts that the foundation has complete control over deciding how the funds are used. Then we get into different types of restrictive funds. First is the designated fund. And this is when your donor specifies one or more charities that receive funds each year. And it's the same year over year. And this is the idea of, I want to support charity X. I want to do it in Y amount. And I want them paid out, you know, X number of times a year or whatever, and this is going to go on year over year. Now, a lot of you ask, can the donor change the designees or the timing of gifts? And what we say is, we understand working with living donors to vary the designation, you know, in a singular or unique circumstance. But if you have a donor that's kind of calling regularly about change this designee, change the timing of the gift, that starts to question ongoing control by the donor. So you just want to watch for those things. And again, variance power in every designated fund agreement. Second type of fund, field of interest funds. Now, when you think about a field of interest fund, this is where somebody doesn't want to designate a specific charity, but they want to give funds for a certain purpose in the community, environment or arts or pre-K education, things like that. Now, fund holders may want to participate in the grant-making process in a field of interest fund. We often see this in the geographic affiliate model because geographic affiliates are fields of interest funds where the field of interest is a geographic area. So if donors want to engage in advising on this fund, the Council on Foundations strongly suggests that you use scholarship fund type rules, which means no one person makes up a majority of the decision, the purpose of the field of interest is clearly laid out, and that your board has ultimate decision-making authority and can accept or reject the advice provided. But you really want to be careful that you have a committee where no one person or group of persons is kind of controlling the others on the committee. And again, we want to see variance power in this fund. The reason affiliate funds fall under field of interest is, again, a geographic affiliate fund, when it is a component fund of the nonprofit or of the community foundation and not an independent 501c3 with just sort of a contract with you. When they are a component fund under you, not their own entity, they are a field of interest fund, and you can call them a geographic affiliate, but in your head you should remember field of interest fund rules, including the important thing, variance power. The next type of fund we have is a nonprofit or agency fund, and those are created by 501c3 entities in your community who want to, most of the time, set up an endowment or set up a fund for a special purpose. Now, variance in power is important in these because many times you get changes in the nonprofit board and staff over the years, and they say, hey, why do we put our money over there? Can't we get it all back? You cannot have a singular statement in here that says, at the request of the nonprofit or agency, they can have the money back. You can say they may request it, but that the community foundation has ultimate legal control and decision-making. So the most important words you can know when you're using variance power and when you're talking to your different types of donors is subject to board approval. You're welcome to chat with us about your fund. You're welcome to tell us things. All of that is subject to board approval. Make those words everyone in your office's favorite saying at their desk. And for the fundraisers, you can use that wording too. It's not too harsh, okay? So you really want to be careful with variance power here and how you say it, because I know a lot of you like to say, oh, hey, in a crisis, we'll consider helping you out, or whether the money should go back or not. But I don't care what you say in meetings, and I really hope you're not overdoing it, but on paper, we want to see variance power, and if you tell them they can request the corpus back, reminding them that is subject to board decision. Also, if you call any advisory boards, advisory committees in this board, remind them that that is not the same as your governing board, because you only got one of those. Okay, scholarship fund, also a restricted fund. Again, donor can create the name of the fund. They can help you with the selection criteria, and they can have input into the scholarship decision-making. But they, their advisors, their related parties, their family, people they do business with, cannot control the ultimate decision in this fund. Now, my favorite thing to argue with the field about, just kidding, I don't like arguing with you ever, is a donor advised fund an unrestricted or a restricted fund? Technically, a donor advised fund is an unrestricted fund, but the community foundation, both in its gift acknowledgement letters and in documentation that the donor receives either the donor advised fund or the donor advised fund policy, so either the fund agreement or the policy, must state that the board has exclusive legal control over these funds. I cannot stress this enough. Some of you have very good fund agreements that clearly explain how this is an unrestricted fund and explain that the donor cannot put on restrictions on the gift, and that the community foundation can work with the donor or use these funds unilaterally. And again, no one's going to put unilaterally in the document, I understand that. But remembering you have exclusive legal control. Now, I've seen, Christina and I have seen hundreds of your fund agreements at this point. And we have to tell you, some of you write donor advised fund language tipping so far into that advisory language and spelling it all out to make the donor happy that it sounds like you're providing them with a material restriction. It sounds like they have a claim in state law under MIFA that they had an advisory privilege as a restriction and that they could try to sue you at the state level. Now, even though a donor advised fund technically is unrestricted, we want to make you aware that how you write this and how you administer it really matters, and it matters to the donor's understanding. It matters to whether or not there becomes an issue with what the donor knew and questioning of whether they got impermissible benefit, that you can prove that you have strong language. So I'm going to get off the soapbox on this, but I'm asking you, please really think about how you talk to your donor advised fund holders and your prospective donors about this fund, because now it was on the Dirty Dozen list with the IRS for a number of years. The 2006 Retention Protection Act came out. We kind of handled it for a while, and this thing has popped back on the radar with policymakers and regulators, and now is not the time to be blurring the line of what is acceptable. Now is the time to be clear with your donors about what this fund can and cannot do. Most importantly, stressing the community foundation has exclusive legal control. Okay. Why not talk about donor advised funds some more while we're here? So a couple of quick things that you need to be remembering in your donor advised fund policies, and again, Christina and I didn't sit around laughing and clicking our fingertips together. We took this information from the rules in the Internal Revenue Code from 4966 and 67. Your donor advised funds cannot make grants, loans, they can't provide compensation, they can't reimburse expenses or similar payments to donor, advisor, or related parties. I know what you're all thinking. Well, if the donor holds an event, can I reimburse the expenses of the event from this fund? No. 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 Don't do it. That's all. Okay. Second, no more than incidental benefit received by a donor, advisor, or related party from a grantee. Can you get your NPR tote bag? Yes. Can you have an NPR radio station? No. You know what I mean, people. Incidental benefit, we all understand what those rules are. Don't let it get further than that. Don't let it get into an area where we're wondering if there's a pledge, or we're wondering if there was front row tickets to Wait, Wait, Don't Tell Me. Actually, that might be incidental benefit. Well, I use the tickets example because when you think about making a contribution out of your donor advised fund to your university, sometimes you like being put into a pool for tickets. And if you get into that pool for tickets, I got to tell you, the IRS, I have talked to regulators, and there is some head shaking at that example. So I don't know. We may see more information about these operational rules. But again, this is the time to stay way far from the line of what might be vague, right? We want you way over in the, we know this is completely acceptable area. Next thing, your gift acknowledgement letter. You're welcome to use one gift acknowledgement letter for everything that you get from donors. But if you're including donor advised funds in that, you've got to state in the letter or in the footnote, and I prefer in the letter, but I understand the footnote, that the community foundation has exclusive legal control over the contributed assets. If you don't have that language, we're giving you back your DAF gift acknowledgement, and we're looking for that language. There's no room to budge on this. Look at your Schedule D of your Form 990 if you wonder why we're so tough on it. Again, non-negotiable. Finally, in your gift acceptance policy, we want to see information about no excess business holdings, and we want this exact language that you see right here. And if you wonder why, or if you say, hey, but we don't accept excess business holdings, we don't care. We still want to see the language in the policy. We understand why you might think that's silly, but here's the deal. When a $10 million business holding comes to the door, you're going to need to have this. And you might not remember that it exists if we don't put it in the policy. So everybody have it. Make sure we don't mess this one up. This is one where regulators, if they find out it's happening, we make them have a bad day. All right, back to scholarship funds. I'm only going to spend a minute here because this is very detailed. We expect to see in your scholarship policy guidelines all of this information, all of it. Look at the sample policy, look at the helpful hints. There is no room for wiggle here. Scholarship funds, you understand what they are. We want to make sure there's no benefit to a person making the selection. So staff members of community foundations, I'm sorry, it's highly unlikely that your children can receive the scholarships from your community foundation. We can talk more about that. If donor is involved, here's all the things you need to remember, right in a row for you, easy to remember. Biggest thing is they're not controlling the selection committee, and that they're only providing advice, and that the community foundation is appointing that selection committee, and the community foundation is making the final decision. When it comes to corporate employees, you got to be really careful when you're administering your scholarships for corporations, and that is because if an employee or their dependents benefit, you get into a tricky situation. So if you're going to deal in corporate scholarships and you're not clear on the rules, call Council on Foundations Legal. They can walk you through it. And if you don't follow these steps, your scholarship fund will be considered a donor advised fund, and that fund and a donor advised fund cannot give grants to individuals, and so you'll be getting yourself into that area where you've got a violation and maybe some excess excise tax. All right, you have heard me talk long enough. So I want to remind you of the resources that we have available for both your standards application, staying up to date, and then promoting the fact that you've done all this very hard work. So this resource page is where you can find a lot of the things that you ask us for the most often. Please note that Christina does an amazing job of upgrading and updating the standards frequently asked questions. So if you ever need to know a question, please check there before you call or email us. We love talking to you, absolutely. But if you can check that, it will help us out a lot in the workload. So thank you, and I'm passing it back to Christina. Oh, one more thing. The Philanthropy Exchange, for those of you who are council members, don't forget you can ask questions about your community foundation operations as you go through the application process on the Philanthropy Exchange and kind of crowdsource answers with your colleagues. So Christina, I hand it back over to you.
Thank you very much, Laura. So this next part, I'm just going to quickly go through the process of applying for accreditation and what that looks like and what it entails. So how do community foundations participate? So first we need to just look at eligibility of a community foundation to participate. So the first point of eligibility is that a foundation must be recognized by the IRS under these code sections, which I'm sure you're familiar with, so 501c3, 509A1, and 170B1A6.
And don't forget, if you give us something that calls your organization a 501c3 or a 509A1, we still need more documentation that says you're specifically a 170B1A6 organization. So if you're providing us with your determination information, we need to see that special number, 170B1A6.
And so the reason for that, like Laura just mentioned, is because this information tells us that your community foundation is actually organized and operated exclusively for charitable purposes and is a publicly supported charity. And so the next is that your community foundation must be in good standing with federal and state regulators. And then also you must meet the national standards definition of a community foundation, and that is explicitly stated in National Standard number 1. And so that definition is as follows. So a community foundation is a tax-exempt, nonprofit, autonomous, non-sectarian, philanthropic institution supported by the public with long-term goals of building permanent component funds established by many separate donors to carry out their charitable interests, supporting the broad-based charitable interests and benefiting the residents of a defined geographic area, typically no larger than a state, and serving in leadership roles on important community issues. So just really quickly to touch on the geographic area, this is one of the things that we often have to mention in our comments when we are going through the application and documents that community foundations provide to us as part of the accreditation process. And so, you know, as you can see here, this is one of the key elements of the actual definition of a community foundation. So it is important that you have that in there so that we can find it and the reviewers can find it. Okay. So just a couple things to think about and take into consideration before applying. So just keep in mind that the actual prep time, getting all your materials together and submitting your application for National Standards Accreditation, it depends on, you know, each particular community foundation, but we see that it generally takes anywhere from about a couple weeks to even a few months.
And that's of uninterrupted time when we say a few weeks. So somebody we hear from a lot of you, and I'm sorry to say this, that you have to do it after working on weekends because you need uninterrupted time. But if you want to play this snippet for your CEO or your board, uninterrupted time means no phone calls every 5 seconds, no emails popping up, no, hey, I just have one quick question. I know your door is closed and I'm not supposed to bother you right now. We're talking uninterrupted time. This is a significant investment of time, but it's not just so that you can say you're accredited. It's so that you can also say your policies and procedures are up to date.
Exactly. And again, just to clarify, this is before you even hit the submit button in the actual online application. And so you want to make sure that you discuss also the value of standards accreditation with your executive committee and your board. You want to make sure that your community foundation has support as you undergo the process. And you are actually required as well as part of the application to provide a board resolution showing that, yes, your board is supporting this and has essentially signed off on it. All right, you also want to look through the accreditation requirements, and it's a good idea to make a list of all the items that you'll need to be approved by the board. That's going to assist you with your timeline, and that'll help you figure out exactly how long it might take your particular community foundation to get all of this together. The legal section of the list of the requirements is probably a good place to start. Because that requires lots of different documentation of your policies and procedures. So that's a good place for you to start. So continuing on with before you apply, so if your community foundation is already accredited, you can find out your accreditation expiration date by checking our website, and the web address is there. So you'll just want to click on your state and then find your particular community foundation, and it will tell you when your expiration date is coming up. If you need to, you can also email us at the submissions@cfstandards.org email address to find this out. But we suggest that you try the Community Foundation Locator first. As Laura said before, we love talking to you and hearing from you, but this is probably a faster way for you to find that information, is going to our website. And also for your first online submission, we are suggesting that you submit between 8 and 12 months before your accreditation expires. That is just because we don't want there to be any lapse in your accreditation status. And once you are at the point where you're doing your online review, so you'll want to submit the renewal materials at least 90 days before your accreditation expires. And so this is something that's new with the online accreditation process, which is the annual renewal as opposed to every 5 years, which is what was in place before. All right, and so now we're actually at the point where you're going to be applying. So you're going to have to visit the online application website to start the process. Again, it's starting in 2015, we moved the process to a completely paperless and online process. You'll just need to create an account using the sign up section, and then you can just start filling out the application. You can save your draft as you go, so you don't have to do it in one fell swoop, but just make sure that you are saving your information as you go along so that you don't lose any information. Once everything is uploaded and all of the sections are completed in the application, definitely want to make sure you review your work, and then you can submit the application. And then just keep in mind, again, that the process is rigorous. It can take anywhere from a few weeks to several months from the time that you actually hit the submit button to the point where you actually get a final accreditation decision. At this time, we don't have an online submission process for payment. So once you submit your application, you will be receiving an email confirming your submission and then also providing you with instructions for how to submit your payment. And you'll just want to follow the instructions regarding payment, and the prices, for those of you who may not be familiar with the cost. For your first online submission, the price is $1,250, and then the annual renewal cost is $1,000. And you can make your payment by sending it to us at Community Foundation's National Standards Board here at this address, 2121 Crystal Drive, Suite 700, Arlington, 22202. So again, you will get instructions about this, but we're also providing it to you here for convenience. This information is also on our website in case you need to go back and find it somewhere as well. All right, so once you have submitted your application and we receive your payment, we are going to go ahead and assign a peer and a legal reviewer to your application. And so each of the reviewers is going to go through everything that you submit. Because it's a really time-intensive process, it can take several months depending on the volume of applications for this review process to take place. And so either myself or Laura will compile the reviewer comments and then email them to you at your email that was used to set up your online application account. And so just, to let you know, it's not unusual for you to get comments back that that are asking for additional information and requests for supplemental materials. That's the whole part of the review process. So just know it's not unusual. You're not the only one that's being asked to provide more information or materials. And so what you'll do is review the comments that you receive back, and then you get the opportunity to respond to the comments and or the requests for additional materials. And we ask that you provide your response within 30 days or after your next board meeting if your updated materials require board approval. And it's likely that any updated materials will require board approval, so just keep that in mind, and we're flexible when it comes to the timelines as well. So,
and please know that we send out bulk reminders sometimes, so everyone who's in applicant response 1 or everyone who's in applicant response 2, just prompting you to remember to do your work. Now, if you get one of those and you say, gosh, I just emailed them and said when my next board meeting is, don't worry, you're getting an auto email. It's a bulk email for everyone in the folder, and you have done nothing wrong, and you should stay right on track where you are. We are not trying to freak you out. Those are just kind reminders that if somebody's put it off to the side, that they need to put it back on the to-do pile.
Yep. So the process of responding to comments from the reviewers can happen more than once. So just keep that in mind as well. You might get some comments and ask for certain documents and or more information, and you might provide that, or sometimes, you know, the reviewers see that a community foundation may have inadvertently forgotten to respond to something. So the reason is that, you know, we know that things come up and sometimes things are missed, and so we want to give you more than one opportunity to pass standards and to come into compliance. So with that in mind, if supplemental materials are requested more than 3 times, then at that point, the National Standards Executive Director, which is Laura, will require a call with your community foundation to discuss the outstanding issues before the 4th submission of materials. And again, that's not because we want to call you out. We don't want to make you feel bad or, you know, upset you, but this is just the process that has been put into place. And again, it's just another measure to help you come into compliance, because we want people to be in compliance. And so once all the national standards are met, the Community Foundation is going to receive an email notification informing them that they are accredited. And the accreditation email is going to have a link to the National Standards Licensing Agreement, and that is something that will have to be signed online. And once that licensing agreement has been signed and returned to us, then there will be an additional email, confirmation email, and that's going to include even more information about national standards and specific links to national standards resources that you can use now that you are accredited. Yay, you're accredited. So as Laura mentioned earlier, we have the National Standards Seal that you can use as part of your marketing materials and communications. And specifically, there is a National Standards Communications Toolkit that is going to be made available to you once you're accredited, which will help share your achievement with your community. And going to renewal, so once your community foundation is accredited, all of your documents are going to be available to you and saved in the online system. So it's going to be all in one online, easy to access location, which is going to make renewal much easier in the future. And the renewal date, again, that's going to be on an annual basis from now on, and it's 1 year after you receive the email notification of your accreditation. And again, you can always go and look at the Community Foundation's locator on our website if you don't remember your expiration date. All right, and so once you're at the point of renewal, each year you're going to go ahead and just review your original application and update any changes that you might have to any of your documents or policies or responses to the application questions. And your application is going to be available to be updated throughout the year as your community foundation makes updates to its policies and procedures. So this is just another way that we're going to provide to you to help you throughout the year and hopefully keep things up to date as they might change. And one last note about renewal, we are asking that you submit your annual renewal and payment no less than 90 days before your accreditation expires. Again, this is just because we want to ensure that there's no lapse in accreditation status. All right, and so there's several different resources that we offer to help community foundations and support them in the process. One of those would be sample documents. So the Council on Foundations legal team has vetted many different sample policies and procedures that are specifically tailored to community foundations to help you in either going through your current documents and revising them, or you can even use the sample policies and procedures that we provide, word for word if you choose to. All right, some helpful hints. So each sample document that's provided is accompanied by a cover sheet of helpful hints, and these are really designed to just help you think through what the policies and procedures should include and why. And so we have online and e-learning resources for webinars and program updates. You can check out the National Standards homepage, specifically the news and events section. And now I'm going to turn it over to Laura again for some more tips.
All right. Has everybody gotten up for a cup of coffee or something? Don't forget, you can pause this. You don't have to sit as long as we've been sitting for this recording. Get up, take in strides, do what you got to do. Okay, so here are tips from your wonderful, and I must say, extremely observant, smart, meticulous, and overall fabulous peer reviewers. I'm always impressed how many things the peer reviewers pick out, and I always wonder, would I have caught that? But they are really fantastic. So here's some ideas from them. First, start early. You heard Christina talk about this. Think about your timeline. Know your accreditation date. Plan, plan, plan. This is a big process. We know that it's painful, but I'm a big fan of project management and planning, and I think that will help. Second, there are no dumb questions. Call and email Christina and I. Don't sit at your computer or talking to your colleagues saying, what the heck are they asking for? Call us. That's so much quicker than trying to figure out our interpretation and not being sure if you got it right. 3, use the samples. And if you do use our samples, or if your state regional has provided you with samples, or if you've used a law firm samples, please maybe add a footnote or a note that says, this document is from the National Standards Sample or the Indiana Philanthropy Alliance or whomever you got them from, so that we kind of know that you're using a sample. We try to do our best to be aware of the samples that are out there, and if you kind of identify for us that you're in one of those categories, it's very helpful to us in the process. Next thing, you can't go back to the future. So this means that you need information that is current, not information that you hope to provide in the future. We need information that you're doing something now, or that you're in the middle of doing that thing. Again, strategic plans, we see this with a lot. Your 990s, your minutes, we need final versions of those, not your in-process versions. If you're in the middle of strategic planning, we understand that can be a multi-year process. Give us a call. Okay, also, read instructions carefully. We are trying to do our best to provide you with as much information as possible in the process, so please use that information we provided. Embrace sameness. I like this. So don't be afraid that something that's past standards before needs to be updated because we've already seen it, or afraid to use our samples. That's what they're there for. Cross-check your information. I cannot tell you how many times our reviewers will look at something and say, you know what they submitted here does not reflect what they put in their gift acceptance, or their bylaws contradict this. I don't know how your reviewers remember all this stuff, but they do, and they are going to notice it. And I know it's hard to remember all the places that you need to update something when you change one thing, but if you don't catch it, just know the reviewers likely will. In addition, they have some practical advice. Page numbers, highlighted information, copies of what you provided us, internal documentation of why you provided certain answers, if it's a yes or no. This is all crucial to helping your peer reviewers review more quickly. If you can point us within your 400-page gift acceptance policy to the key elements we look for in all gift acceptance policies, like your excess business holdings, we're going to go a lot quicker than if we're kind of guessing where things are. Next thing, there should be integrity in the process. We've tried to streamline. I know you're laughing at me as I say that, but we do our best to try to continue to improve your submissions process, and we'll continue to try to do that in the future. And remember that these are a learning tool. It's something we get calls. We actually just got a call yesterday of somebody saying, this really made me feel like I know how to run the community foundation after going through this process. So don't forget that the learning tool part of this is really valuable. Again, please promote your accreditation, but promote it with the new seal. I won't overemphasize this point, but please promote the new seal. And then share accreditation. Send a letter to your district offices of your policymakers saying, hey, did you know that we're accredited and what an accreditation means? Share your accreditation to incentivize people to become board members. Like, hey, we're in good shape. You're joining a really savvy organization. Come join us. And use the Marketing and Communications Toolkit. We've done a refresh on that, and we hope that you will be using it. We provided the resource links earlier. Also, compete for the HUD Secretary's Award for Public, Private, or Public Philanthropic Partnership because you receive bonus points. And we've had many reasons to celebrate those HUD Award winners year over year that also have standards accreditation. All right. So don't forget cfstandards.org. That's the website, and it contains all the information. The search tool that we have is excellent. That's what I use. When you call me, the first thing I do is start typing into that. So don't be afraid to go through that website and look around. And one thing a lot of you ask us is, how is the council engaged with the standards program? And so we want to take a few minutes to explain that. First, the council supports the program monetarily and with staff. So Christina and I are sitting here partly because of funding from the Council on Foundations. We are not a fully supported program just in our fees that we charge. And I know that's probably new information since you all had your fees go up, but those fees still do not cover all the costs. Second, the council believes in the standards, and they believe in promoting the standards when they talk to congressional policymakers, state policymakers, and state and federal regulators. So please know that the National Standards Accredited Community Foundations are part of who the Council on Foundations serves in their policy work. In addition, the council's legal team created all those samples that Christina and I keep telling you to use. So they really invested a lot of time in over 40 samples so that you have great guidance for going through this process. Further, the council's leadership underwrote the implementation of the online application. For those of you who are doing the online application for the first year, you know that you used to provide paper binders. And when people are surprised that the process takes 12 months now, imagine how much longer it took us when we were doing things with paper, and how your peer reviewers either had to come to DC or have boxes shipped to them and then shipped back of your reviews. So all that was possible because of council funding. In addition, The council's policy team, like I said, does a lot of education. They arrange opportunities for policymakers to actually get briefings on standards. I have done several, maybe many of those at this point. And the communications team continues to promote standards in council's publications. So the value of standards accreditation is really elevated by the Council on Foundations promotion of the program. We also have management and licensing agreements to work together. And again, this is pretty in the weeds, but just so you know that there is that support. Finally, if you need Christina or I, we are here to support you. This is our contact information. We both check the standards email. Our phone numbers are both available to you. I will be honest, sometimes I have Christina locked up in a room doing standards reviews where she can't be uninterrupted because, like I said earlier, uninterrupted time is very important, both for you as you put your application together, but also as she reviews. Please know we're not actually locking her in a room. That was a joke. See, she's laughing. She's not locked up somewhere. And I am often on the road, as many of you know, because you've either seen me on the road or you've seen my away message. So while there are two of us, and we do our very best to be as responsive as possible, please understand that there are blackout periods where one or the other of us is not available, but that doesn't mean that we shouldn't be responsive to you. So look to us. We really enjoy working with you, and we look forward to more work with you in the future. And that's all I've got. Christina?
That is it. Just want to thank everybody for listening in. And again, like Laura said, feel free to contact us. And we wish you luck in your accreditation journey. Thank you.
Thank you.